Let's now move on to the other big story, again related to a court judgment. A day after a court in Kolkata sentenced Sanjoy Roy to life in prison for the rape and murder of a postgraduate trainee doctor at the RG Kar Medical College and Hospital. The debate rages on when does one get the death penalty. In his order, the judge emphasized the rule of law and judicial objectivity must prevail over public sentiment or an emotional response. The judgment is 172 pages long. It came down heavily on the role of the Kolkata police, from whom the CBI took over this investigation. The court condemned the Sub-Inspector Subrata Chatterjee, who was the initial investigating officer, for what it called illegal acts and failure to follow investigative protocols. The court also observed that there was poor crime scene management and a lack of thorough crime scene preservation, both of which are absolutely critical for any investigating and prosecuting agency to be able to prove a case beyond reasonable doubt in a court of law. The judge also noted that the victim's body was cremated hastily. This, remember, the victim's parents had also said the exact same thing right from the day this crime happened, that they were pressurized to do the cremation in a fast manner. The court observed that the cremation and the hasty nature of the cremation broke standard protocols. Requests from the family, including a second post-mortem, were ignored by the police. The judgment also observes that the police personnel restricted the victim's family from entering the crime scene. The judge also observed that senior officials of the Kolkata police allegedly attempted to offer cash to the family, something that's been corroborated by written statements from the family members themselves. Inconsistent and conflicting communication with the family during the course of the investigation. There were delays and irregularities which were observed in registering the case and lodging the complaint by the victim's parents, which raises concerns about deliberate obfuscation by the police. So the court and the judge not pulling back any punches when it comes to what it felt was the role of the Kolkata police in the initial days in the probe of the RG Kar rape and murder. Meanwhile, the West Bengal government has seemingly got a fillip from the judgment yesterday. It has now said it is because of the botched up investigation by the CBI that the court has not granted the maximum possible punishment, which is the death penalty. The state government has now approached the Calcutta High Court demanding the death penalty for the convict. Mamata Banerjee also took to social media before the Advocate General moved the High Court's division bench to say, and I quote, "I'm really shocked to see that the judgment of the court today finds that it is not a rarest of rare case." Remember, for the death penalty, the prosecuting agency has to prove beyond reasonable doubt that it is a rarest of rare case. "I am convinced," Mamata Banerjee writes, "that it is indeed a rarest of rare case which demands capital punishment. How could the judgment come to a conclusion that it's not rarest of rare? We want to and insist upon the death penalty in this most sinister and sensitive case. Recently, in the last 3 to 4 months, we have been able to ensure capital punishment for convicts in similar crimes. Then why in this case has the capital punishment not been awarded? I strongly feel that this is a heinous crime that warrants the capital punishment."
আমরা ফাঁসি চাই। যারা এত পৈশাচিক অত্যাচার করে, যদি কেউ দানবিক হয়, যদি কেউ পাশবিক হয়, তাহলে সমাজ কি মানবিক হতে পারে? সমাজকে মানবিক করতে হবে। মা বোনদের সম্মানের স্বার্থে আমরা অপরাজিতা বিল পাস করেছি অ্যাসেম্বলিতে। আমরা ডেথ পেনাল্টি রেখেছি, সেখানে আমরা শাস্তি রেখেছি, এবং অ্যাসিডেও অনেক সময় মুখটুক পুড়িয়ে দেয়, তার জন্য আমরা শাস্তি রেখেছি। সেই বিল আমাদের পাস করা নিয়ে এখনও কেন্দ্রীয় সরকার এবং ফেলে রেখে দিয়েছে। আমরা চাই সেটা একটা মডেল তৈরি হোক এবং দেশে এটা মেনে নেওয়া হোক।
ये बताइए कि कल जैसे हमने देखा कि आप कोर्ट में बोला कि हमको कॉम्पेंसेशन नहीं चाहिए, हमको जस्टिस चाहिए, रेयरेस्ट ऑफ द रेयर केस नहीं है, उसके बाद में क्या कैसे लड़ाई आपका शुरू हुआ, क्या रिएक्शन है आपका?
शुरुआत का रिएक्शन यही होगा, सीबीआई जो काम किया है, सीबीआई ने जो चार्जशीट दाखिल किया है उसका अंदर ऐसा कोई एविडेंस नहीं दे सका, इसलिए कोर्ट को बोलना पड़ा ये रेयर ऑफ रेयरेस्ट केस नहीं है और संजय को फांसी का सजा नहीं सुना है। ये पूरा सीबीआई का गलती है।
वाले कंपेंसेशन आप क्या अभी भी नहीं लेंगे? और जब कान में सुनाई दिया कि नहीं होगा कैपिटल
इसलिए हमको कल कोर्ट में बहुत दुख आया। ये कंपेंसेशन पहले दिन जब चीफ मिनिस्टर हमारा घर में आया था, उन्होंने भी कंपेंसेशन देने का कोशिश किया। पहले दिन 9 तारीख को रात जब मेरा लड़की का डेड बॉडी हमारा घर में लाया था, डीसी नॉर्थ ने भी कोशिश किया था हमको रुपया देने का। ये रुपया हमको दे के क्या चुप कराना चाहते थे? यही हमको दिक्कत है। इस बहुत दुख का बात हमको राम के लिए।
See, we raised some questions in the form of the argument that there has been some latches from the part of the investigation agency. We have submitted a written set of argument in respect to that, and also we have verbally argued the fact that there are some other aspects that should have been looked into while investigating into this matter, which is been missing. Rather, sir, there are some latches from the part of the investigation agency. And the Learned Court on the previous day has categorically stated that that has also raised a confusion in his mind, and he has also criticized the same regarding the role of the investigation agency and also the role of the authority of the Arjikor Medical College and Hospital. Today, the sentence has been pronounced regarding that this accused person may be convicted to life imprisonment, and the copy of the judgment is yet to be published. And unless and until I get the copy of it, because the Learned Court has categorically stated that he has answered all our questions.
and say
Whenever
that it's not the rarest of the rare case.
And that was has been argued by the defense counsel, and in his judgment the reason of this penalty, rather the life imprisonment other than the death penalty, is explained in his judgment. So unless and until I get the copy of it, I cannot elaborate the fact.
Big question and the real outrage around this story is, what then qualifies as rarest of rare, and why did the judge come to the conclusion that this was not a rarest of rare case? Now, there are aggravating circumstances and there are mitigating circumstances for when a judge can come to the conclusion that this is a rarest of rare case. The aggravating circumstance is that the crime must be extremely brutal and it has to be culpable, both of which it was in this case. The mitigating circumstance is the judge has to go very, very thoroughly into the offender's background, whether there is a previous criminal record, the mental state, was he in a non-violable mental state at that point of time when the crime happened? Is there a potential for reconciliation and rehabilitation, for reform? Because ultimately the purpose of law is for reformation, not so much for punishment. So that must be considered as well. Collective conscience. Did the crime shock the entire collective conscience of society, as this case certainly seemed to have done? Was it an uncommon crime? It has to be an unusual crime. No alternative punishment should be viable once the judge has come to a conclusion that yes, there is a conviction to be made out. Also, public abhorrence. The crime is so heinous that it warrants a public abhorrence, something that the judge warned against, that it has to go as per judicial precedent and not based on some emotional response. And that the punishment should also respond to society's cry for justice. One of the reasons why the Nirbhaya accused, the Nirbhaya convicts eventually got the death penalty, was because it had to appeal to the nation's collective conscience or collective cry for justice.